What are you going to read here is about the ESA's report about the court cases of people versus video games. There have been many efforts on the part of state and local legislative bodies to regulate access to games. However, courts, including the US Supreme Court, have ruled 13 times that computer and video games are protected speech, and efforts by the legislative bodies to ban or limit access to or the sale of games they find objectionable and will inevitably run afoul of the First Amendment of the U.S. Constitution. $3,223,916 total amount state and local taxpayers have repaid the entertainment software industry for its legal fees. Video games qualify for First Amendment protection. They protected books, plays, movies. They communicate ideas through familiar literary devices and feature distinctive to the medium. And the basic principles of free speech do not vary with new and different communication medium. Justice Antonin Scalia, U.S. Supreme Court. So without further ado, let's begin this. U.S. Court of Appeals for the Seventh Circuit, American Amusement Machine Association and Company versus Kendrick and Company, 244 F3D 572 of March 2001. In a unanimous three-judge panel, the Honorable Richard A. Posner of the Seventh Circuit declared that Indianapolis Arcade Ordinance unconstitutional, reaffirming that children have First Amendment rights. In his ruling, Judge Posner stated that to shield children right up to the age of 18 from exposure to violent descriptions and images will not be only be chaotic, but deforming. It would leave them unequipped to cope with the world as we know it. Maybe video games are different. They are, after all, interactive. But this point is superficial, in fact, erroneous. All literature, here broadly defined to include movies, televisions, and other pornographic media, and popular as well as highbrow literature is interactive. The better it is, the more interactive. Literature, when it is successfully draws the reader into the story, makes him identify with the characters, invites him to judge and quarrel with them, to experience the joys and sufferings as the reader's own. Protest from the readers caused Dickens to revise Great Expectations to give it a happy ending. Then the tourist visits sites in Dublin and its environs in which the fictitious events of Ulysses are imagined to have occurred. The cult of Sherlock Holmes is well known. In reference to scientific studies, such as research by Craig Anderson and Company, provided to the court arguing that interactive games cause violent behavior, the court wrote, there is no indication that the games used in the studies are similar those in the record, or of this case, or to other games likely to be marketed in game arcades in Indianapolis. The studies do not find that video games have ever caused anyone to commit a violent act, as opposed to feeling aggressive or to have an average level of violence to increase anywhere. And they do not suggest it is the interactive character of the games as opposed to the violence of the images in them that is the cause of the aggressive feelings. The studies thus are not evidence that violent video games are in any more harmful to the consumer or to the public safety than violent movies or violent but passive entertainments. It is highly unlikely that they are more harmful because passive entertainment aspires to be interactive and often succeeds. After striking down the Indianapolis Arcade Association as constitutional, the court ordered the defendants to pay the arcade industry $318,000 to cover the attorney's fees in this case. Now, I want you to remember the name Dr. Craig Anderson because his works are going to be cited and his name are going to be mentioned many times in this reading. If you're curious what his studies are about violent video games in correlation to aggressive and violent behavior, it's on the low bar. U.S. Court of Appeals for the 8th Circuit, IDSA versus St. Louis County, 329 F3D 954-957, June 2003. On September 25, 2002, in a unanimous decision of a three-judge panel, the Honorable Morris S. Arnold of the U.S. Court of Appeals for the 8th Circuit struck down the St. Louis violent video game law and found that the First Amendment protects a wide array of content, including video games. The 8th Circuit held that if the First Amendment is versatile enough to shield the painting of Jackson Pollock, music of Arnold Schoenberg, or Jabberwocky verse of Lewis Carroll, we see no reason why pictures, graphic design, concept art, sounds, music, stories, and narrative present in video games are not entitled to similar protection, and went on to elaborate on First Amendment protections, stating that we do not mean to denigrate the government's role in supporting parents or the right of parents to control their children's exposure for graphically violent materials. We merely hold that the government cannot silence protected speech by wrapping itself in the cloak of parental authority. To accept the county's broadly drawn interest as a compelling one would be inviting legislatures to undermine the First Amendment rights of minors willy-nilly under the guise of promoting parental authority. Regarding the concern that video games are harmful to minors because of their content, the court found that the county's evidence and once again studies of Craig Anderson and company to be unpersuasive. The opinion stated that the conclusion that there is strong likelihood that minors who play violent video games will suffer a deleterious effect on their psychological health is simply unsupported in the record. This vague generality falls far short of showing that video games are psychologically deleterious. The county's remaining evidence included the conclusory elements of the county council members, as more of ambiguous, inconclusive, or irrelevant, conducted on adults, not minor studies, and the testimony of a high school principal who admittedly had no information regarding any link between violent video games and psychological harm. When First Amendment rights are at stake, the government must present more than anecdote and supposition. After striking the St. Louis law as unconstitutional, the court ordered the defendants to pay the video game industry $180,000 to cover attorney's fees in this case. U.S. District Court for the Western District of Washington, VSDA and Company versus Malling and Company, 325 F Support 2D 1180, July 2004. In July 15, 2004, the Honorable Robert Lasnik of the U.S. District Court for the Western District of Washington permanently enjoined a Washington state law that would prohibit the sale of video games that depict violence against law enforcement officers. In this ruling, Judge Lasnik rejected the state's argument that video games should be regulated under obscenity law and declined the U.S. state's invitation to expand the narrowly defined obscenity exception to include portrayals of violence. Judge Lasnik wrote that such depictions of violence have been used in literature, art, and in the media to convey important messages throughout our history, and there is no indication that such expressions have ever been excluded from protections of the First Amendment or subject to government regulation. Reinforcing First Amendment protections afforded to games, Judge Lasnik wrote, the games at issue have storylines, detailed artwork, original scores, and a complex narrative which evolves as the player makes choices and gains experiences. All of the games provided to the court for review are expressive and qualify as speech for purposes of the First Amendment. In fact, it is the nature of effect of the message being communicated by those video games in which prompted the state act in its sphere. Dismissing the claims that of the state's expert witnesses and studies presented, Judge Lasnik determined that the court finds that the current state of research cannot support the legislative determinations that underline the act because there have been no showing that exposure to video games that trivializes violence against law enforcement is likely to lead actual violence against such officers. Additionally, Judge Lasnik found the state's attempt to ban the sales of games depicting against law enforcement officers was impossibly vague and failed to give a person of ordinary intelligence to a reasonable opportunity to know what is prohibited so he may act accordingly. Striking down the Washington law as unconstitutional, Judge Lasnik ordered the state of Washington to pay the video game industry $344,000 to cover their attorney's fees in this case. U.S. District Court for the Northern District of Illinois, IDSA and Company versus Prokofiev and Company, December 2005. In a strongly worded 53-page decision, Judge Matthew Kennelly permanently enjoined the Illinois Violent Video Games Law and Sexually Explicit Video Games Law on December 2005, resoundingly dismissing the research in support of the statute presented by the state of Illinois. But Judge Kennelly ruled that the state has failed to present substantial evidence showing that playing violent video games cause minors to have aggressive feelings or engage in aggressive behavior. The decision came after a 3-day trial in which the state presented testimony from Dr. Craig Anderson and Dr. William Cronenberg in support of its position. With respect to Dr. Anderson's claim that, that violent video games can cause aggressive behavior, the court said that neither Dr. Anderson's testimony nor his research established a solid causal link between violent video games exposure and aggressive thinking and behavior. Research in this field have not eliminated the most obvious alternative explanation. Aggressive individuals may themselves be attracted to violent video games. In response to Dr. Cronenberg's claim that violent video games cause a reduction in brain activity, the court said that there barely any evidence at all, let alone substantial evidence, showing that, that playing violent video games causes minors to experience a reduction in the frontal lobes of the brain, which is responsible for controlling behavior. In his decision, the Judge Kennelly found fault with the argument that legislation is the answer to protecting children from inappropriate media, writing that if controlling access to allegedly dangerous speech is more important in promoting positive psychological development of children, in our society that role is property accorded to parents and families, not the state. Finally, Judge Kennedy determined that the state may have compelling interest in assisting parents with regulating the amount of media violence consumed by by their children, but it does not have a compelling interest in singling out video games in this regard. In fact, the under-inclusiveness of the statute, given that violent images appear more accessible to accompanied minors in other media, indicates that regulating violent video games is not necessarily intended to serve the pre-offered purpose. After striking down the Illinois law as unconstitutional, Judge Kennelly ordered the state of Illinois to pay the video game industry $510,000 to cover their attorney's fees in this case. And here's another quote. The court finds that the current state of research cannot support the legislative determinations that underline the act because there have been no showing that exposure to video games that trivializes violence against law enforcement is likely to lead to actual violence against such officers. U.S. District Court for the Eastern District of Michigan, IDSA and Company versus Granholm and Company, April 2006. On April 3, 2006, the Honorable George K. Ramsey of the U.S. District Court for the Eastern District of Michigan issued a permanent injunction halting the implementation of this Michigan bill, which sought to ban violent video game sales to minors. In his decision, the Judge T firmly dismissed that the state's claim that the interactive nature of video game makes them less entitled to First Amendment protection. The interactive or functional aspect in video games can be said to enhance the expressive elements and even more the media by drawing the player closer to the characters and becoming more involved in the plot of the game than by simply watching a movie or television show. Judge T wrote, "It will be impossible to separate the functional aspects of a video game from the expressive, inasmuch as they said they are so closely intertwined and dependent on each other in creating the virtual experience." Regarding the science presented in the state purporting that show the link between video games and violent behavior and thoughts, the court said Dr. Craig Anderson's studies have not provided any evidence that a relationship between violent video games and aggressive behavior exists. It then had that have evidence introduced, alleging that the new brain mapping studies show a link that between violent games and aggressive thought is equally unpersuasive. The research not only fails to provide concrete evidence that there is a connection between violent media and aggressive behavior. It also fails to distinguish between video games and other forms of media, Judge T wrote. Addressing the state's claim that video games are more harmful than TV because the player controls the action, the court said that there is no evidence to support such claim, adding that it could be as easily as said that the interactive element of video games acts as an outlet to minors to vent their violent or aggressive behavior, thereby diminishing the chance they will actually perform such acts in reality. Not only the act not materially advance the state's stated interest, but it appears that to discriminate against a disfavored newcomer in the world of entertainment media. Thus, singling out the video game industry does not advance the state alleged goal, Judge T concluded. On November 30, 2006, Judge T ordered the state of Michigan to pay ESA, AAMA, and the Michigan Retailers Association $182,000 $1,000 in attorney's fees and the cost of a result of a 2006 permanent injunction granted in favor of the video game industry. U.S. District Court for the District of Minnesota, ESA and Company versus Hatch and Company, July 2006. On July 31, 2006, the Honorable James S. Rosenbaum of the U.S. District Court for the District of Minnesota issued a permanent injunction to halt implementation of a Minnesota law which sought to penalize minor for the purchase of rental or of M or AO rated games. In his decision, Judge Rosenbaum stated that there's no showing whatsoever that video games, in the absence of other violent video, can cause even the slightest injury to children. The court then raised questions about the legislature's motive in passing such an obviously unconstitutional law, stating several other states have tried to regulate minors' access to video games. Even every effort has been stricken for violating the First Amendment. The court will not speculate as the motives of those who launched Minnesota's nearly doomed effort to protect our children. Who after all, opposes protecting children? But the legislatures drafting this law cannot have been blind to its constitutional flaws. Like all other courts to rule on this issue, Judge Rosenbaum rejected the signs presented by the state purporting to show a link between violent video games and violent behavior and thoughts. Should the injunction be granted, the state argues that children of Minnesota's psychological well-being and ethical and moral development will be harmed. The problem with this argument is the state's inability to show the truth of this position. As shown above, there is a paucity of evidence linking the availability of video games with any harm to Minnesota's children at all. A person, indeed a legislature, may believe that there is a link and a risk of harm, but absent compelling evidence, the belief is pure conjecture. The state professed concerns, in the absence of evidence showing them to be well-founded, do not outweigh the chilling effect of free speech that would result from the act becoming effective. The court also rejected the state's attempt to incorporate ESRB's ratings into the law, stating that as such a delegation of authority to a private entity, it violates the First Amendment. The court found the retailer signage requirements unconstitutional as well. In March 2008, the U.S. Court of Appeals for the Eighth Circuit upheld the district court's ruling. The Attorney General then requested an en banc review of the appellate decision. The Attorney General's motion was denied in May 2008. On June 30, 2008, Minnesota paid the ESA $65,000 in attorney's fees and expenses as ordered by the court. U.S. Court of Appeals for the Seventh Circuit, ESA and Company versus Bakokchevich and Company, November 2006. On November 27, 2006, the Honorable Anne Claire Williams of the U.S. Court of Appeals for the Seventh Circuit ruled in favor of the ESA and reaffirmed the U.S. District Court for the Northern District of Illinois' ruling that granted a permanent injunction for halting implementation of Illinois' sexually explicit video game law, SEVGIL. The state of Illinois appealed to the district court ruling with regards to SEVGIL, but not to the portion of the law that deal with violent video games. In his opinion, Judge William reaffirmed the court's observation that the children had First Amendment rights, stating that history has shown the dangers of giving too much censorship power to the state over materials intended for young persons. The court ruled that the SEVGIL failed to meet the standards required by the First Amendment. More specifically, the statute definition of sexually explicit failed to meet the prong of the three-pronged test required by the Supreme Court for the regulation of obscene material. Judge Williams further stated that the state of Illinois created a statute that is constitutionally overboard in failing to include language in the statute that is sexually explicit material taken as a whole does not have serious literary, artistic, political, or scientific value as required by the Supreme Court test. Judge Williams also discussed state's exclusion of the requirement that any material in question can be considered as a whole in determining criminal penalties. The judge used the video game God of War to illustrate the point that the overboard nature of the SEVGIL makes likely to prospect of criminal prosecutions for the sale of games that have social importance for minors. As expressed by the court, there is a serious reason to believe that the statute sweep too broadly when it prohibits a game that is essentially interactive, the digital version of the Odyssey. Finally, the judge stated that a Sevgil could not survive constitutional muster because the state failed to consider other less restrictive alternatives to the Sevgil. Most obviously, the state have simply passed legislation increasing awareness among parents of the voluntary ESRB rating system. The court also affirmed that the district court's holding that the Sevkil's signage and brochure requirements are unconstitutional. Judge Williams found the signage requirements overboard, stating that little imagination is required to envision the spacing debacle that could accompany a small retailer's attempt to fit three signs, each roughly the size of a large street sign, into such space. The Seventh District awarded ESA's attorney's fees for the appeal in the amount of $34,550. U.S. District Court for the Middle District of Louisiana, ESA and Company versus Fody and Company, November 2006. On November 29, 2006, the Honorable James Brady of the U.S. District Court for the Middle District of Louisiana ordered a permanent injunction to block implementation of a Louisiana statute that's seeking to ban the sale of violent video games to minors. Remarkably, Judge Brady issued his ruling from the bench rather than through a written order or opinion, and stated that he was granting permanent injunction based on the reasoning behind the court's August ruling, which granted a preliminary injunction. In his August decision, Judge Brady wrote that the state have overlooked a series of previous cases that found that video games are protected free speech. According to the opinion, video games, as much as is entitled to protection of free speech, are as the best of literature. With regard to the social science presented, the judge stated, it appears that much of the same evidence has been considered by numerous courts, and in each case the connection was found to be tentative and speculative. The evidences was submitted to the legislature in connection with the bill that became the statute is sparse and could hardly be called in any sense reliable. Significantly, Judge Brady found that less restrictive alternatives which would achieve the state's goal exist, including encouraging awareness of the voluntary ESRB video game rating, which provides guidance to parents and other consumers, and the availability of parent controls that allow each household to determine which games their children can play. Judge Brady also granted the ESA's attorney's fee in the amount of $91,900. In his orders granting attorney's fees, he stated, this court is dumbfounded that the Attorney General and the state are in the position to having paid taxpayer money as attorney's fees and the cost of this lawsuit. The act, in which the court be found to be unconstitutional, passed through committees in both the State House and Senate, then through the full House and Senate, and to be promptly signed by the governor. There are lawyers at each stage of this process. Some of the members of these committees are themselves lawyers. Presumably, they have staff members who are attorneys as well. The State House and Senate certainly have staff members who are attorneys. The government has additional attorneys. The Executive Council. Prior to the passage of the Act, there were a number of reported cases from a number of jurisdictions which held similar statute to be unconstitutional, and in which the defendant was ordered to pay substantial attorney's fees. The court wonders why nobody objected to this enactment of the statute. In this court's views, the taxpayers deserve more from their elected officials. U.S. District Court for the Northern District of California, VSDA and Company versus Schwarzenegger and Company, August 2007. On August 6, 2007, the Honorable Ronald White of the U.S. District Court for the Northern District of California ruled in favor of the VSDA and ESA's motion for summary judgment, permanently enjoining enforcement of the California violent video game law. The law would have prohibited the sale to minors of games depicting killing, maiming, dismembering, or sexually assaulting an image of a human being. The court acknowledged that video games are protected by the First Amendment and found there was no evidence that playing violent games results in real-world violence. In reviewing prior cases, Judge White noted that while none of the cases holding violent video games law constitutional or Ninth District cases binding onto this court, they nevertheless reflect a strong judicial antagonism towards such laws that this court should not ignore. While Judge White found that the state has not shown that the act will accomplish the goal of protecting children more effectively than existing narrower industry standards. The court is not suggesting that the ESRB standards should be adopted as law, but rather mentions those standards as one that support the state's interests but do not involve state intrusions on First Amendment rights. With respect to scientific evidence, Judge White found that there is none showing that violent video games, in absence of other violent media, cause injury to children, nor does it establish that video games, because of their interactive nature, are more harmful than movies, television, or other speech-related exposures. Finally, Judge White said that there are some terms in the statute that are broad and not sufficiently narrow. The state currently appealing Judge White's decision on August 6, 2008, the state of California reimbursed ESA $282,794 for attorney's fees incurred during their motion of summary judgment as ordered by the court. U.S. District Court for the Western District of Oklahoma, AAMA and Company versus Henry and Company, September 2007. In September 17, 2007, the Honorable Robin J. Cochran of the U.S. District Court for the Western District of Oklahoma issued a permanent injunction against the state's unconstitutional attempt at regulating computer and video games, ruling that video games are a form of creative expression entitled to protection under the First Amendment. In her decision, Judge Cochran also found that there is no support or substantial evidence that video games are harmful to minors. There is a complete dearth of legislative findings, scientific studies, or other rationale to support the passage of the act, Judge Cochran wrote. Judge Cochran addressed the issue of computer and video games interactivity. She found that the presence of increased view control and interactivity does not remove these games from the release of First Amendment protection. The court also ruled that the law was inclusive because a minor prevented from a video game with inappropriate violence may still be legally buy or rent a book or movie in which the game was based. On July 7, 2008, the state of Oklahoma reimbursed ESA $56,367 for attorney's fees incurred in the case. U.S. Court of Appeals for the Eighth Circuit, ESA and Company versus Swanson and Company, March 2008. On March 17, 2008, the Honorable Roger Leland Bowman of the U.S. Court of Appeals for the Eighth Circuit affirmed the decision of the U.S. District Court for the District of Minnesota that the Minnesota statute to penalize minors for the purchase of or rental of M or AO-rated games violated the First Amendment. The court held that the state must come forward with incontrovertible empirical proof that a causal relationship between exposure to video game violence and subsequent psychological dysfunction, which the state failed to do. U.S. Court of Appeals for the Ninth Circuit, Video Software Dealers Association and Company versus Schwarzenegger and Company, February 2009. On February 20, 2009, the U.S. Court of Appeals for the Ninth Circuit issued a unanimous ruling that upheld the U.S. District Court for the Northern District of California's permanent injunction of California's violent video game law. Upon exhaustively reviewing the research and studies provided by the state, the Honorable Consuelo M. Callahan stated that the court has found that there was no substantial evidence that supports the legislature's conclusion that violent video games cause psychological or neurological harm to minors. Judge Callahan continued by stating that their remaining less restrictive means of forwarding the state's purported interests, such as improved ESRB ratings, enhanced educational campaigns, and parental controls. U.S. District Court for the Northern District of Illinois, ESA and Company versus Chicago Transit Authority and Company, July 2009. On May 7, 2010, the Honorable Rebecca L. Hallmeyer of the U.S. District Court for the Northern District of Illinois granted a permanent injunction to prohibit the ban of violent video game advertisements by the CDA. George Paulmeyer previously granted preliminary injunction against the CDA on January 27, 2010, ruling that the ESA was likely to succeed on the merits of its claim at trial. In her decision, Judge Paulmeyer stated the advertisements the CDA wishes to ban to promote expression that has constitutional values and implicates core First Amendment concerns. ESA filed the case in 2010, challenging CDA's prohibition of certain computer and video game advertisements as a violation of guarantees of free speech under the First Amendment of the United States Constitution. The court ruled against the CDA, dictated that prompt notice of the judgment be given to CTA officers and any agents, servants, employees, and attorneys. The CTA agreed to not appeal or otherwise attack the validity or enforceability of the consent judgment and permanent injunction, which will recoup attorneys' fees and costs to the ESA. U.S. Supreme Court, Brown versus Entertainment Merchants Association / Entertainment Software Association, June 2011. On June 27, 2011, the U.S. Supreme Court announced its decision in the case of Brown versus EMA / ESA, originally filed as Schwarzenegger's EMA / ESA, ruling in favor of the ESA. The court 7-2's decision struck down a 2005 California statute that would have regulated the sale and rental of violent computer and video games to minors. The ruling stated that computer and video games are entitled to the same constitutional protections as books, movies, music, and other forms of artistic expression. In the majority opinion, Justice Antonin Scalia said California had not shown that video games were harmful to minors. Psychological studies purporting to show a connection between exposure to violent video games and harmful effects on children do not prove that such exposure causes minors to act aggressively. Of the least restrictive requirement for all attempts to limit free speech, the court stated California also cannot show that the act's restriction meet the alleged substantial need of parents who wish to restrict their children's access to violent videos. The video games industry's voluntary rating system have already accomplishes that to a large extent. The court challenged California's attempt to create a new category to restricted speech. The state wishes to create a wholly new category to content-based regulation that is permissible only for speech directed at children. That is unprecedented and mistaken. The country has no tradition. This country has no tradition of specifically restricting children's access to the fiction of violence. The court also questioned the state's reasoning for singling video games out from other expressive works, noting that classic children's stories such as Hansel and Gretel, the complete Brothers Grimm's fairy tales, Cinderella, and all contain elements of violence, as do other media that children are exposed to. Since California has declined to restrict those other media, example given, Saturday morning cartoons, its video game regulation widely under-inclusive, raising serious doubts whether the state is pursuing the interest it invokes or is instead disfavoring a particular speaker or viewpoint. In sum, the majority have found that that California law does not meet the strict scrutiny standard of content-based restrictions on free speech, that it therefore does not comport with the First Amendment. Well, after reading those court rulings, now you're going to ask yourself, Homer, why did you brought this up? This have nothing to do with Anita Sarkeesian's argument. You know what they say, it's all for the greater good. And these people are doing their best to actually censor video games without actually respecting the First Amendment rights of people. And besides, the studies that they've shown, citing Dr. Craig Anderson, have proven nothing at all. As for Anita Sarkeesian, well, if you have an argument like this,
paradoxically, and somewhat ironically, those who most strongly believe that media is just harmless entertainment are also the ones most likely to uncritically internalize harmful media messages. In short, the more you think you cannot be affected, the more likely you are to be affected.
it's just proof that she don't have anything to prove about video games causing subliminal sexism. Her theories are insubstantial, her theories don't have a leg room, her theories don't stand a chance against US courts, or any court for that matter, because she don't have anything, as in anything, to prove that video games causes sexism, like these people who says that video games causes people to be violent, especially minors. Her argument goes like this: if I'm holding a knife, I might have a chance to be a mutilator, I just don't know about it. But even if I don't hold a knife, I'm still susceptible to being a mutilator, and I just don't know about it. See what I'm going there? Now spread this around if you find this really helpful. Anyway, I'm Homer, and I'm going to enjoy my donuts. Don't judge me. See you later.